Good afternoon, this is Sean Golding with Golding & Golding, here to discuss the basics of a very serious issue in the offshore disclosure world, minor offshore tax non-compliance by someone who is willful. Can they still qualify for the Streamline program? Do they have to do voluntary disclosure? Quick recap, right? What is willfulness? Willfulness is the intent to avoid reporting. In the civil arena, it doesn't require actual intent. It can include reckless disregard, willful blindness. This is as opposed to non-willful, where you have many other options available to you. So a common problem with inexperienced counsel is they haven't been around the block. They haven't done any intense sort of audits and things like that. So you go to one of these guys or gals and you tell them your situation, and they go, oh, it's willful, but it's a minimal amount of money. It's minor infraction. You can still go streamlined. That's absolutely incorrect. In order to go streamlined, you have to be non-willful, and you are making a proactive representation to the IRS under penalty of perjury. I can't think of a worse idea than if you were willful and then you go streamlined and you're certifying proactively. So you're going out of your way to contact the IRS and lie under penalty of perjury and certify that you're non-willful when in fact you were willful. There's no what's called de minimis rule. What a de minimis rule means is that if there was a minimal amount of money, maybe you can still qualify for a certain program. It doesn't exist. So simply because it's a small amount of money, it doesn't mean you qualify as non-willful. The converse is true too. I mean, we get lots of clients who contact us here and they go, hey, I didn't know I was supposed to report, and I reported, and I spoke to an attorney, and this attorney told me I need to sign right now. I need to sign a retainer immediately, hand over a power of attorney, and not speak with any other counsel. That's also a horrible idea. If you're non-willful, simply because you learned about it after the fact, and you feel bad about it, and the attorney can hear that on the phone, or think, oh, I should have known, maybe sort of I could have known, right? Everyone's got 20/20 hindsight. That's the other problem. So the way that some of these inexperienced firms will try to catch you when you're willful and send you streamlined is that they'll say something like, well, I have 100% success rate. I haven't had any audits. Whether that's true or not, it doesn't really matter, because the standalone streamline program was introduced in July 2000 or June 2014. Most of these cases fall under the 6-year statute of limitations. So 2020 is the first year that anyone could even possibly outrun the audit situation. So if by 2025 someone hasn't been audited, they're probably going to be fine. But if you submitted in 2018 or 19 or 17, that time for an audit has not expired, which is why it's also important that whatever firm you hire provides you some audit protection on the back end. There shouldn't be an additional fee, but something that they should provide to take care of you in case something like that happens. Yes, for the most part, only considering that the IRS has limited resources, they will more likely go after higher income earners and higher account balances, but that's not always true. We get approached many times throughout the year by people who were audited, and they wouldn't necessarily consider themselves to be big fish. If you are considering doing one of these amnesty programs, it's important to speak with different experienced attorneys. Most experienced attorneys in this field will have 20 years experience. They'll be board certified. They'll be duly licensed. They'll have a master's of tax law degree, and some extensive audit type of experience. There are various types of programs, and there's nuances to each program. It's important that you have a pretty solid understanding before you strike. There's the Voluntary Disclosure Program, which has been around forever, but since they got rid of OVDP, it's been expanded since the end of 2018, early 2019. It is essentially for people who cannot certify under penalty of perjury that they're non-willful. It has nothing to do with criminal. Some of these people will scare you into streamline when you're willful by saying, oh, if you do voluntary disclosure, you're a criminal. The difference between there's a huge difference between criminal willfulness and civil willfulness. You're not signing a plea deal or anything like that with voluntary disclosure. Depending on what your facts, you may have a better deal under the new voluntary disclosure than you would under prior OVDP. Not always, but sometimes. There is the streamlined filing compliance procedures, the domestic and foreign program, depending on whether you're a U.S. resident or not. And if you qualify, there is the delinquency procedures or reasonable cause. We have lots of free resources on our website, goldinglawyers.com. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.